witness statement, do you demonstrate with numbers how your alleged errors in the figures impacted in any material way the final outcome of the 2020 presidential elections? Nowhere.
My Lord, it's not a matter of figures. It's not a matter of figures being put in my witness statements. It has more to do with a trend of anomalies, several anomalies. And we were seeking a forum for a proper presentation of those issues.
Okay.
We were seeking a forum for the proper presentation of those issues.
Well,
For example,
well said.
Can I give an example?
You can't give examples here. Now,
For an example.
Now, I'm referring.
Respectfully, why can he not give an example?
Because I'm referring to his witness statement.
He's cross-examining. The witness is saying, I want to give an example to explain my answer. Why is that disallowed?
Mr. Metulunu, you can go ahead with your examples.
My Lord, for example, the Eastern Region 2 summary sheets that were presented, the total number of valid votes as recorded on those two sheets was the same. But in one of them, Nanado had much higher figures being attributed to him. The petitioner's votes were reduced, and similarly, all the other presidential candidates also had their figures reduced. But the totals of that second summary sheet was the same. That was the specific fraud. That was the specific manipulation. That was the specific anomalies that we're referring to. How is it possible that the same regional office can submit two separate results? On the face of it, the total vote cast is the same, but then the vote attributed to each of the candidates was taken. And in one of them, our candidate was not present to sign or to vet or verify. And then you are tendering both of them. Which of them is the original and which of them is the genuine result? Which of them? In another instance, you have a whole constituency, the results not recorded, and yet the summary sheets have been submitted by the EC regional representative of the returning officer. And if I sign that in error, and I come back and tell you that I have observed that that is an error, why can you not address it? Because the regional summary must have 100% of all the constituencies' results as tabulated, and not that you have one omitted. It cannot stand as a summary. And in the same instance of examples, I observed several of those summary sheets having errors in figures and words which affected the summary of the total.
Yes.
Several of them.
So my point here is that you have not given this court the details of the figure as to affect the outcome of the elections. That's the point I'm making. I'm putting it to you.
My Lord, the question is muffled.
Have you not given
The
it?
question is muffled by, and I can't hear the question properly.
I'm saying, putting it to you, that you have not presented to this court the details of the figures that have a material effect on the overall outcome of the 2020 presidential elections. That's what I'm putting to you. And it's on the
My Lords,
of the record.
My Lords, I have alluded to I have alluded to anomalies that, if tabulated, would add up to the figures. I have raised in my statement of 32 points that in specific anomalies that I noted, this was the case. How is it that that does not refer to figures? I may not have given you specific figures, but I've given you instances in Ashanti, in Eastern Region, in Bono East, in Northern Region, in Greater Accra. In Eastern Region, where these things have been seen and noted, it's a reference to the mathematical infractions. It's a reference. And if the court was well, please, you ask the question. The candidates you represent, they benefited hugely from these anomalies that I'm referring to, benefited, and that resulted in the board result that was declared.
See, I don't know. The whole your cross-examination is on I put it to you, I put it to you, I put it to you. I'm wondering whether that's all that lawyers do in a courtroom. So I put it to you, I put it to you, I put it to you.
My Lord.
Because there is cross-examination.
Yes, my Lord.
And what I'm expecting is witness control.
Yes, my Lord.
And because there's no witness control, that's why the witness is going on a tangent. And I don't know how many more I put it to use you have before we close this.
My Lord, the record of his evidence is before the court. If I put it to him and he says something else, that is a journey in futility.
But why not exercise witness control? There's a way in cross-examination to control the witness. So to agree with what you want the witness rather than to leave the witness and to go on a tangent. Because we can continue with this for the next...
So, Mr. Metonunu, you see, in the Eastern region, you will see from the record that a whole constituency's vote was omitted in the first summary sheet of the region. So what happens in the second summary sheet was...
My lords, respectfully, the counsel cannot give evidence. Counsel cannot give evidence. What happened in the second sheet, that's evidence. It cannot be allowed as a question.
See, Mr. Metanunu, the first witness of the petitioner appeared before this court and admitted to the correctness of the second summary sheet for Eastern Region.
My lords, that is not an accurate account of that first witness's cross-examination. In any case, that witness for address, please.
No. Mr. Metonunu, I am saying that you should take a look at the two summary sheets from Eastern Region.
Which summary sheet are you referring to?
The Eastern Region summary sheets.
You must refer to a specific time of transmission because that will tell me which one. Is it the summary sheet? Is it a summary sheet
Please listen to the
that was collated at 9:39 a.m.? Is that the summary sheet of 9:39 a.m.?
Mr. Metonunu, you said there
Yes,
were two summary sheets from the Eastern Region. The lawyer is asking you a very simple question. He says, look at the two summary sheets from Eastern Region. You look at it, and maybe the question will follow. You don't go off like we are going. You not even finish today the way you want to over-elaborate on some of these simple matters. He said, just look at the two summary sheets from Eastern Region. Then you leave him to follow up with his question. That is all. If it is not before you,
Very well.
If it is before you,
Very well, my lord. Very well, my lord.
Now, you will notice that in the first summary sheet, which you signed, you have as the total valid votes 1,196,751 as the total valid votes.
That is not what I have in front of me. The total valid votes here is 1,236,940.
So just pay attention. You see, on the second but last column, you'll see 1,196,751. Is that okay?
I am not sure I am seeing what you are talking about.
I'm talking about the second but last column of the columns on that summary sheet. Second but last column.
My lord, I cannot see the specific reference to which you are. I cannot see it.
Where you have total valid votes. Second but last column. Where you have total valid votes.
And also, I think it will help all of us if we know exactly what document is being referred to, because I think we really.
Yes.
And if we.
Let me see where we are going.
Two are attached to Mr. Sejun Ketia's witness
He
statement.
may not have
Yes.
two different times.
Yes.
So mention which one you are referring to. So the witness will know.
I'm referring to my Lord, it's not this 8:56 a.m. p.m. Sorry, it's 8:56 p.m. on the 8th of December.
The documents, yes, they're referring to Asidun. This is in reference to Asidun Kitia's witness statement. And in reference to that witness statement, to the extent that it relates to Eastern region, I do not see the 8-something p.m. Yeah.
Mr. Apotampa. One? Here.
Exactly.
9:39.
Exactly. Exactly. That is what we also have.
Yeah.
My learned friend has been. I'm sorry. Yes, but I'm saying apparently he has a different one because he's quoting from a document which he says showed up at 8 something.
No.
That's what he said.
My Lord,
Maybe he can show us the 8 p.m. one so that we see whether it fits with anything that we have.
my Lord, that's the first document.
Mr. Kotambo.
Yes, my lady.
Mr. Sidon Petet tendered 2.
Yes.
Headed Eastern Region. Both were signed by the Regional Coalition Officer Faith Amejake. Is that what you have?
Yes, my lords. There is the one with the blue stamp.
That's 9:39.
That's the 931.
Yeah.
9:39.
Yes.
A.M.
And then there's an earlier one.
No, we don't have an earlier one. We have a later one, which is 6:40 p.m.
The 8th on it is the date.
Yes.
8/12/2020 is a date.
Yes. Which is 6:40 a.m.
Yes.
40 p.m.
It's
p.m. p.m.
Put on your spectacles, Mr. Kotambo.
Oh. My lady, I think that
I was only teasing. It's
Something different from what we are speaking to.
no, my lord, we do not. Now, our point is, if one were to add yes, my lord, if one were to add all the figures attributed to the different candidates, on the one with the blue mark,
That's 9:39.
yes. Which does not have your signature. You arrive at 1,236,440. 940, sorry. Is that correct? Is that correct? Yes. But my lords, because there is an error of addition when you go through them.
My lords, that is correct.
Yes.
You will get 1,236,940.
Very well. Now, if you take the summary sheet that you signed and you do the addition of the actual figures, you will see that it is less 40,189 of the 1,236,940. In other words, if you add all the figures, the votes that the candidates obtain, you will get a total which is less of 1,236,940.
I think you're overloading your question. You should break it down.
Okay. So I'm putting it to you that if you add all the figures on the sheet that you signed, you get a total of 1,196,751. That's the actual total you get.
My lords, if I may, if you look at the totals without looking at the attributed figures to each candidate,
Mr. Metil,
you'll be making a big
he's
mistake.
asking you the figure that you get. Please, when you respond to it, then you can give your commentary.
That is correct. That is correct. Can I go on now with the explanation?
Hold on. So
On the 9:39 a.m. figure, you find that they gave to Nana Addo 752,061, and on another sheet he gets 729,146. But the total number of votes cast is the same. The total number of votes cast in the two documents in contention are the same.
So just take your time. So I'm saying
The total number of votes cast is the same.
yes, hold on. I'm saying that the difference between the 1,196,751 and the 1,236,940 is 40,189. That's the difference.
That is the case.
Yes. And that figure of votes is exactly the total valid votes cast in Asensuano, Ahinsiano.
Mr. Akutuamba,
Yes.
you did this with the Mr. Asedun Kitia.
Yes.
So what are you trying to do now? Get something different or
No.
to corroborate him or what?
My Lord, that's why I put it to him that this was, as Asedun Ketia actually admitted that there was an error. Very well. Very well.
It's not the admission.
Yes, and to add up, Mr. Sedun Ketia, it was he who attached these documents
Yes.
to his witness statement.
Yes.
You have cross-examined him on it. He has admitted the difference. Mr. Metunono has not attached any such thing to his witness statement.
Right.
Why do you cross-examine him on somebody else's documents?
No, my Lord, he referred to it in his response. That's why. You know. So, you see, I am suggesting to you that nowhere in your witness statement do you show how your alleged lack of transparency and consultation had an impact on the final outcome of the elections. You have not shown it.
My Lord, that is correct. But I made an aversion that there were anomalies, that there were serious anomalies.
My Lord, that will be all for the witness.
No re-examination.
There will be some few questions from the bench.
Good. Mr. Rojo Metunono, you have admitted in this court that you left at a point in time to go and see the petitioner. Is that so?
That is correct, my Lord.
You have also admitted that you signed most of the summary sheets, the original summary sheets, 13 of them, out of 16.
That is correct.
Good. Now, did you sign these summary sheets before you left to see the petitioner?
Yes, I did sign the 13th before going to see the petitioner.
Okay, thank you.
Can the witness be discharged, Your Lordships?
By court, PW3 is discharged as a witness.
Most grateful. That is the end of our case.
Okay. By court, the case for the petitioner is closed. Yes. Yes, Mr. Amenuvo.
My Lord, with respect, it's our submission that in view of the evidence led by the witnesses of the petitioner and our cross-examination so far, speaking for the first respondent, I'm of the view that there's sufficient evidence before the court for this petition to be determined. And therefore, my Lord, yes, my Lord, I was saying that giving the evidence of the petitioner's witnesses and the cross-examination so far, of those witnesses, my Lord, speaking for the first respondent. Yes, my Lord, it is the first respondent's case that we do not wish to lead any further evidence, and therefore we are praying that this matter proceeds under Order 36, Rule 4.3, and CI 87, Rule 3E5, and we hereby, on that basis, close our case. That is so. That is so.
Mr. Amenuvo,
yes, my Lord.
What then happens to your witness statement?
Well, my Lord, under CI...
You file a witness statement?
Yes, my Lord.
And the witness statement is supposed to be subjected, it's going to stand as your evidence in chief.
Yes, my Lord.
And therefore, it's supposed to be subjected to cross-examination.
Yes. My Lord, under CI 87 Rule 3E5, where if a party who has served a witness statement does not call the witness to give evidence at the trial or put a witness statement in as hearsay evidence, any other party may put that witness statement in as hearsay evidence. So, my lords, we are saying that we are not calling any further witness. If the court decides to treat our witness statement as hearsay evidence, well, the court is entitled to, but we are not leading any further evidence. We are not calling evidence.
Did the rules say the court can treat it as hearsay? So any party?
No, the party, a party, not the court,
So
sorry.
not the court, yeah.
The other side can treat it as such. Thank you.
My lords, respectfully, we need to understand the nature of what is being put forward clearly.
In a nutshell, it is our submission that given the evidence from the petitioner, to a petitioner's witnesses and the court examination so far, speaking for the first respondent, we do not wish to lead any evidence. We submit that we are not calling any evidence and close our case. Then he refers to Order 36.
Order.
Refer to Order 36. Yes, sir. Order 36.
My lords, Order 36, Rule 4.3, with your kind permission, if I may read. Where the defendant elects of CI 47, my lords, where the defendant elects not to adduce evidence, then whether or not the defendant has, in the course of cross-examination of a witness for the plaintiff or otherwise put in a document, the plaintiff may, after the evidence on behalf of the plaintiff has been given, close the plaintiff's case, and the defendant may then state the case for the defendant.
Respectfully.
Yes, my lord, CI 87 on what will happen to the witness statement if you choose not to enter the box, my lords. Rule 3, that's sub-rule 3E, sub 5.
Your alternative is to have it.
It is our respectful submission that counsel for the first respondent does not have it open to him to take the course that he just proposed to this court. Order 36 Rule 4.3 that he refers to specifically says where the defendant elects not to adduce evidence. In these proceedings, the defendant has put in a witness statement. So, my lord, I'm sorry.
Yet evidence. It is just a statement.
My lords, what this provision says, where they elect not to adduce evidence. And what I'm saying is that the election that they made to submit the witness statement to the court is a clear indication that they made an election to the contrary. Because, my lords, in these proceedings, at the point of case management, your lordships basically ask questions from all the parties as regards witnesses being called. And it is at the point of case management where such an election is notified to the court. At that point, they elected to submit a witness statement. Now, that witness statement is not yet in evidence. That is true. But this is referring to an election. The point of election came at the point of the case management. And we are respectfully submitting that this witness cannot run away from cross-examination when they have elected. My Lord, when they have elected, that is the point. They have elected. They have elected to
the language, please.
Oh, my Lord,
maybe you can invading, but run away.
My Lord,
it is being a telecast, and people may interpret it.
I will adopt your words. So if your Lordship,
yeah, he is evading.
Evading, my Lord. I will totally adopt your Lordship's words. I will totally.
Yes, please, you have the opportunity to. Yes.
Yes.
Assuming we were not dealing with witness statements.
I'm sorry.
Assuming we were not dealing with witness statements, and we were giving oral viva voce evidence, when would you say that a party has elected not to give evidence? Assuming we were not using witness statements.
At the case management stage. If the party at the case management, my Lord, at the case management stage, the party may, no, otherwise the case management stage is meaningless.
No. If a party is called upon to testify, and then he tells the court, I do not intend to testify, that is when we will say that the party is not willing to adduce evidence.
My Lord, respectfully, that is not the situation under the rules as amended to provide for case management.
Order 36 is proceedings at trial. So we have moved into trial stage. Order 36 deals with proceedings at trial.
I appreciate that, and the point I'm making is that Order 36 is premised on where the defendant elects not to adduce evidence. So, my lords, what I'm saying respectfully is that in the context, Order CI 47 obviously precedes CI 87. And in the context of CI 87 and the provisions for case management, the case management context is a context in which, for the purpose of a trial, the judge asks the parties how they are going to proceed. That's what I understand case management. Your lordships have had many occasions to point out the significance of the case management process. And my respectful submission is that it is in that case management process where, one, the party gives an indication to the court that I intend to call these witnesses. Now, if the party gives that indication, then respectfully, the party has made an election to adduce evidence. And my lord, that is the basis on which the court made orders at the stage of case management as to when witness statements should be put in. The court made orders on the basis of the election that they had. So,
no, Mr. Giza's point of correction. The orders for witness statements is made at the application for direction stage and not at the case management.
The orders
it's made on the order 32, at the application for direction stage.
But my lord, that is the situation here is different from the pure high court situation, because in this case, at the case management stage, in this situation, we did not have a direct application for directions, my lord. We did not have that. I believe that's common ground between us. So in this case, we move to the case management stage. And in the case management stage, the court makes orders on the basis of representations that are made to the court by the parties. And respectfully, the representation that was made to the court at that stage is that we are going to call a witness, and we will provide a witness statement on behalf of that witness. That's the clear indication that they gave. Otherwise, the court would not have made an order, submit your witness statement by such and such a date. That is very clear, my lord.
I wish to come in, Mr. Chikata. Now, are you saying that if you decide to call 5 or 6 witnesses and you put in 5 or 6 witness statements, you cannot at any point in time tell the court that though you have put in 6 witness statements, you are not going to call all the 6? Can't you say that?
My lords, you can say that.
Yes, please.
My lords, you can say that, but that is not what is dealt with in Order 36.3, which is what they're coming on.
You see, under the normal civil procedure, if the prosecution closes its case, and that may be the plaintiffs, that's what I'm using prosecution in the civil sense, for the plaintiffs.
My lords, with the greatest respect, yes, let's just stick to what we're familiar with. If you say prosecution in the civil...
Okay, so if the plaintiff closes his case, and the defendant realizes that the case the plaintiff has made has no substance, or does not establish the reliefs he is claiming, and there will be no need for him to testify, you know, he can tell the court that he will not testify. And then he will be put to his election. Whether, if the court rules in respect of his application, he will still testify or he will not testify.
My lord,
that is the procedure.
My lord, with the greatest respect, that is not the procedure under our rules. With the greatest respect, that procedure may apply under the English civil procedure rules, but it does not apply under our rules. And with the greatest respect, if I'm wrong in that, I would stand to be corrected. Which rule under our rules has that provision?
It's a settled practice.
My lord,
we adopt. So are you saying that, my lord, a party cannot say that I will not testify, judge the case according to the evidence you have?
My lords,
because you cannot compare anybody to testify.
My lords, with the greatest respect, my lords, with the greatest
order in court, please.
With the greatest respect, I wish to take it a step at a time. If your lordship is referring to a submission of no case at the end of testimony, if that's what your lordship is adverting to, my respectful submission is that, one, under English common law, it is in fact not available in a trial which is not before the jury. Under common law, the authorities are clear that that process that your lordship just described is not available. And I am prepared to cite some authorities in the common law which make that clear, including a well-known case of Alexander and Racine. But, my lord, before coming to that, I just wish to clarify that the common law position is very clear. Where there is a jury, it is open under the common law. Where there's a jury, it is open for when there's a jury, it is open for the plaintiff to say indeed that I don't want the matter to go before the jury. I'm ending at the point of the trial judge. But the common law position that has been clearly stated in the English Court of Appeal is that where there is only a judge and not a jury, that procedure is unacceptable. And there's a very clear reason given for it in the authorities, which I'll come to. But, my lord, I want to...
Mr. Chiket, I want to understand something. Are you suggesting that a party can be compelled to give evidence?
My lord, that is not what I'm suggesting. I'm just suggesting that Order 36 Rule 3 applies in terms of the precondition that is put there. In terms of the precondition, it says where the defendant elects not to adduce evidence, then whether or not the defendant, and I'm saying respectfully that in this case, the first respondent elected to give evidence and notify the court as such. The first defendant elected to give evidence, notify the court as such, and on that basis, the court made an order for a witness statement to be provided.
Mr. Chikata, you are aware that at case management stage, nobody knows the evidence that the others bring. It is after case management audits that the testimonies come in. Is that not it?
Very clear. I mean that's a matter of chronological necessity, because that is a chronological necessity. A case management happens before witnesses are called to testify, so there can't be any doubts about that. I'm referring to the fact that under Order 36.3, which counsel for the first defendant is seeking to come under. And my lord, this is also different from the submission of no case under the common law.
If you excuse me, Order 36 for sub-rules 2 and 3 together. You say subject to sub-rules, the plaintiff shall begin by opening the plaintiff's case. Then 2, where the defendant elects not to adduce, 3, where the defendant elects not to adduce evidence. It presupposes that the plaintiff has finished his case. That is my understanding. I stand to correct it.
My lord, respectfully, that cannot. Respectfully, that cannot be the case. Because my lord, Order 36.4.3, and respectfully, as I said, those rules predated CI 87 on case management. CI 87 introduces case management, on the basis of which your lordships have proceeded and given orders. And respectfully, I'm submitting that under the terms of CI 47, Order 36, Rule 3, where the defendant elects not to adduce evidence is a precondition for that. And in this case, the defendant at the case management stage represented that they would adduce evidence, and therefore that precondition does not exist. And the defendant made those representations to the court and to the court in a manner which led your lordships to determine.
Mr. Chikata, may I seek clarification?
Yes, my lord.
Are you suggesting that under the case management regime, a defendant who indicates to the court before evidence is taken that I will call 1 or 2 witnesses in this matter, then after the plaintiff has given evidence, the defendant says, I don't think I need to call any evidence. Determine the matter on the basis of what the plaintiff has brought. Cannot do so?
Yes, my lord, I'm saying that he cannot do so where the court, on the basis of their representation, has ordered witness statements to be submitted. Because where he does that, he has elected other than what is provided for in Order 36.4.3. Where he makes that election at the case management stage, and the court has made an order appropriately.
Mr. Secretary, you realize that Order 36, Rule 4 is only regulating order of speeches.
My lord, I didn't quite.
Order 36, Rule 4.
Yes, that's the next.
Only regulating the order of speeches. That's all that the rule is seeking to do. But a trial.
Yes, but my lord.
But how can the law state that a party compel a party to give evidence by all means?
No, my lords, respectfully, if you say that the order of speeches is all that.
Yes, order of speeches.
Yes, my lords, that's a head note, and your lordship knows very well that the head note does not settle the interpretation of the provisions. I mean, Bernard Mona's case is a classic instance where the head note was shown to be completely different. And in fact, if we were only dealing with order of speeches, then my learned friend is completely out of court, because if that provision is only to do with order of speeches, then he cannot, on the basis of that, be asking your lordships to do or be telling the court what he told the court. If it's just order of speeches, then it will be interpreted as such. So it cannot be just order of speeches.
These proceedings are...
I'm sorry.
Of Order 36, these with proceedings are trial.
Yes, but Order 36(4), as his lordship pointed out, is order of speeches. That's what your lordship pointed out to me, and I agree. It says order of speeches. And I'm saying that the head note cannot limit the terms of that order, respectfully, because in fact, if your position were to be accepted, respectfully, then you should throw him out of court completely, because we are not yet at the point of order of speeches. We are not yet at that point. So if all that 36 Rule 4(3) is dealing with is order of speeches, then all he said is irrelevant, because we're not yet at order of speeches. But the reality of the matter is that head note cannot limit the terms of Order 36 Rule 3. I believe that.
Mr. Chikasa, isn't compelling someone to testify a human rights question?
Also, my lords, I'm sorry. My lords, this is new territory. I mean, I have to think of it because frankly,
nobody can compel a party to testify.
My lords, frankly, I have to give considerable thought. In fact, yes, I have to give considerable thought to what you're saying, that you're not...
as I'm sitting here, I'm reviewing this whole thing.
Yes.
I mean, nobody can compel a party to testify.
My lord...
That's a very basic rule.
My lady, as I said, I mean, your ladyship has been part of a ruling in this court which said the right to vote is part of the directive principles of state policy.
Mr. Chigata, please, may I have your attention?
Yes.
Please, none of us, at least those on the bench, none of us anticipated this step.
Exactly.
So please come, both of you come and address us on this point tomorrow. Then you will give a ruling on it and then proceed accordingly.
My lords, I was actually going to make a similar submission because it is my respectful submission that for an application of this nature under Order 19, it should be made in terms of a motion paper and a supporting affidavit so that we can respond appropriately. No. Because, my lord, that application that is being made...
Please, with all respect, please, there's nothing factual about this application. Yes. Let's take it. If he comes tomorrow to raise this legal issue, you have the opportunity to reply. So please, just prepare.
Very well.
And bear with us tomorrow.
Very well. Very well.
Yes. Please, we want to know your position because you have also filed a witness statement.
Yes. My lords, we do not intend to call any witness.
Okay, then you prepare.
And my lord, let me complete.
Order.
We do not intend to call any witness because in our view, they have not satisfied the burden of proof. So we can't be forced to call any witness.
Please, we don't want lengthy answers. Please, what we want you to do is to prepare, come and address us on it tomorrow. then we will give a reasoned ruling on it and proceed accordingly. Thank you very much. Please, you will rise for the day.
I know.
Please be seated. Be seated, please.
Please, attention of the bench has been drawn to the fact that immediately after proceedings, counsel from both sides resort to granting interviews to the media. And at times, some of them keep on twisting the facts, which actually occurred in the court, and seek to even prejudice whatever the court proceedings were. So lawyers who are engaged in it are to please have a look at Regulation 55 of LI 2423. Yes, that is the legal profession etiquette, conduct and etiquette rules. Please, if I may read 55C. So, a lawyer shall not publish or cause to be published a material concerning current or potential proceedings, including proceedings for which the lawyer is engaged or seek to be engaged, which is inaccurate or has received comment or necessary description. Then C, is calculated or is likely to a material degree to diminish or be prejudicial to the public confidence in the administration of justice. Please, I think both sides have been guilty of it, and especially my dear sister, Marietta. At times, yes, you made statement even touching on the demeanor of witnesses. So please, it's a passionate plea from the bench. Let's respect the ethical rules. Yes, yes, Mr. Opon too, you were also guilty of it because you were at the news file, and we think that since you have been announced in this case, it is unacceptable. Yes. Mr. Menuvo, your name appears on this LI. Yes. Yes. So please, yes. Yes, as a member of the General Legal Council. So please, let's take our own rules seriously.
Yes, but my Lord, speaking for myself, I have never...
No. I'm drawing your attention to it. Your name appears.
Yes, my Lord.
Yes.
So it is encouraged you not to do.
Yes.
Order in court, please. Order.
By court, this petition is hereby adjourned to Tuesday, the 9th of February 2021 at 9:30 a.m. for legal arguments. It's okay.
You don't need a wig. No, you don't need it. You don't need it at all.
All rise.
Yeah.